So these are the changings. There are some other changings to one of your, I would say, favorite Zambrano Kinsania case. That's been the decision was came few days back. Most of you already have our number. The number I can again repeat them: 0780 300 1377. Most of the updates that we received, and I also update on the Facebook page, our Marvelox page, and the WhatsApp status on this number. So they may have seen it, and most of you, I can say that they have seen, and yeah. But I would also explain briefly. But before we jump that, I would give you like, if you can, if the next topic you have, you can.
Thank you, Mr. Fahad, for explaining us about immigration law.
Thank you.
If anybody have any question, kindly contact with Mr. Fahad. We already given their number and email address. So now we will start about family law.
Okay.
So let's start with divorce.
Okay, that's fine. Okay, I can. Okay, that's fine. Let's start with the divorce, and then we come back. Well, we still have to come back on fee waiver and spouse anti-clearance. So let's do the family now. Okay. So I understand that you may be thinking that people are still listening immigration. That's why you have changed to divorce, which is really good for our audience, that they. We don't want them to get bored with one topic. So divorce is one of the when it comes to divorce, which is obviously very sad, very sad. Of course, remember we had this discussion that we're going to have this topic. Even that time we discuss people, they may do not want to listen this, because those who are in couple spending happy life, we wish them good luck with the future, with their kids and with their partners. But those who are in trouble and they're looking for someone to apply for divorce, now you have quickest option. Those who have applied divorce before March 2022, the family court is still there is a huge backlog on that. So most of them, even our clients, they call us, they ask us, and I always tell them that this is something is not in our hands, that we have to follow the procedure, we have to follow the law. When someone comes for this, we are here at Marvelox to advise you guys that what would be the best option. You still have option for paper, which delays your case. The quickest way is the online option that people can go. Don't forget the fee. Which is over 500. It's around 550. Please forgive me if I'm not giving the right figure. So the divorce process takes time when you submit. Then, but I would also add up another thing, that after 50 years in the Family Act law, especially in the section of divorce, there has been a major change, big change. There used to be the grounds that you must have to give before you have to apply the divorce. Like, it has to be a reason, maybe the behavior of the person is not right, adultery, and some 2-year separation, 5 years, and you had to comply under the procedure, under the legislation. But now the major change that has been made by the government, that you do not have to necessarily, you do not have to show that there is any reason, as long as both parties are happy for that. And I think for those who as I said in the beginning, it's not good to say that when we come to divorce and ending the relationship, it's not a good news. Obviously, it's a sad news, but of course we have to, in the world, we have to run things along with our life, how we want to spend our life. So with the divorce, I have previously explained several times, and it takes time. The party receives, they sign the petition, petitioner and respondent both, and the court issues certificate of entitlement. Then one of the party can apply for the next thing, they can apply for decree nisi. Then once the court issues them decree nisi, the court also allows them 6 weeks. In that 6 weeks time, those who wants to go for financial dispute, like the property, the belongings, your bank balance, your assets are involved in there. So in that 6 weeks, the court allows you 6 weeks. If you guys patch up again for somehow, then you can just inform the court, and then your matter will be resolved. You are not going to go towards the decree absolute. So decree absolute you can apply after six weeks, but only if you have not gone through the financial dispute. That is very, very important. When the parties, they are separating, if the money is involved, assets are involved, then of course they want to have their shares. They want to divide the shares. Whoever has spent more money towards the household, property, anything, or bank balance, assets. So people, the thing I would say, a very important point here, when people they come, they said, okay, what's the starting point? If I go through that route, what's the starting point? And then they say, if we have mutual understanding with that, yes, you can go through the consent. You can draft a consent between the parties, and then you can submit this to the court, rather than you going and challenging each other. The starting point, of course, it depends on the situation, that how much we always, when they provide the details, we go through it, and what the actual document says, that who spent more, who was working, who was household, who was housewife. Even nowadays, most of the husband, I would say house husbands, so their wives is working, they stay home, look after children, and they actually work couple, they work together and spend money to their asset together. So this is something that we have to look into it. We just cannot advise saying on the statement when client they come and they ask the starting points. The starting point we can only advise when we see the document, that who spent what. So if the financial dispute is not there, then I would say that the court gives you 6 weeks to apply for another application, that then finalize your divorce process, which is called this decree absolute. Once you receive that, and then you are legally separated. Okay. So another important point here, many people they ask, they say, okay, my divorce is still in process, can I go for my marriage because I'm in the relation? Because most of us, we know there may be a reason when couple is not happy to live together, or there may be a reason if one of them has found another one, or maybe a reason if one of the person has applied for divorce, then the second may have, because you always go through the stress and all that, and then you need someone partner, and then you always try to find someone. If someone has been through the same situation or are in the same situation, then they need to know that they have to finish this first process before they jump to the second marriage. So this is very, very important point for those who are in the same situation. Any further advice for future, you may have seen the studio number, you can see on the screen. You can also contact us directly at Marvellock Solicitor. My number is there. I'll repeat that again: 0780 300 1377. Any question you can ask, you can call, you can come to the office. Our address is 2A Median Road, ground floor office, Hackney Central. We just 3 to 5 minutes walking distance from Hackney Central, we the ground floor office, and the postcode is E50PL. They can come and contact us. 30 minutes. I have heard so many of them. They complain that oh, we have to pay this much. We have to. But I always say, first 30-minute initial consultation is always free, and those who are already watching this or are going to watch, they 100% know that what I'm talking about. It's always when they call and contact me, it's always 30 minutes free consultation that I provide them. If they have to hand over the case, then we can, of course, there is a legal fee involved, and of course if something goes beyond 30 minutes and a person only wants to have advice, so they can even come and we can discuss everything. So that is how it is. So before we jump to other family law topics, let's go back to two important main
Yeah, definitely.
Okay, please. Okay.
So just explain the about fee waivers.
Okay. So the fee waiver is one of the very, very important and hot topic that I have come across and noticed that people they actually want to know. There are two fee waivers that I would like to say. The one fee waiver that has recently came up for those children under 18 wants to apply for citizenship. They can, because let me explain. People, when they have indefinite leave to remain, so their question is, oh, when I'm going to apply for British passport? No, you don't apply for British passport directly. You first apply for citizenship if you have indefinite leave to remain. Under the spouse route, 5 years spouse route, you don't have to wait 12 months. Any other category, you wait 12 months and then you apply for citizenship first. And then once you get your citizenship certificate, then you can apply for British passport. You do not directly apply for that. So this can be checked in the Nationality Act. This can be checked if they most of them are clients. I'm so happy they already know that. They read and they come and ask questions. I'm so happy that we, through our channel, through different platform, we especially myself, I always try to educate them, so they should understand. They should also understand the things that I have noticed. Most of them, when they come, they ask. So my concern is to give them proper advice under the legislation, under the guidance of the Home Office. And so most of them, they already know that when they come to me directly. And none of the client who visited us in the past and who has not been benefited from us, I wouldn't say there is even a single person. because with us we quite straightforward. If we see that you differ under the law, I would tell them, yes, come, and we would help you to get this through. Because if someone, most of them, even they ask, is there any guarantee? I always say to them, there is no guarantee of anything. If someone is giving you guarantee, that means the person is lying to you, because we lie. We prepare your case, we submit to the Home Office, we read the guidance, we read the case law, and then according to that we see what is your situation. Do you differ under that? Do you qualify under that? And then we explain to our clients in client care letter that how what we advise you, what you instructed us, we mention in there, and then everything we mention very clear. So it will be always for anyone who comes to us, the services will be the same, because we at Marvel-Locks, we are known best for our services, which is one of our basic element of the firm, that we are the best in the services. In regards to the fee waivers for children, first, the government has made recent changes to that. Those individual, previously it was £1,012 for children who were going to apply for the British citizenship. As remember, Etisham, me and you having this discussion in the past, when we selected this topic, and this is something was not a happiest thing for those parents, that they had to spend £1,000, and it's not easy to earn that £1,000 in this country. Those who are working hard, it's the money values for them, for everyone, but those who working hard and struggling to get money to pay to their lawyers, of course, on top of that, once they are paying home office fee, then to their lawyers, solicitors, they are paying their money as well. So those whose children are going to do qualify for that, for British citizenship, we may take this topic in future, that who are the one going to qualify for this British citizenship, but who are under 18, they can now apply for fee waiver. So fee waiver actually saves them that 1,000-1,200. Now, another very important topic. I know if we, I know those hot topics that we have discussed today. Yes, I know people are definitely concerned that how we should go through it. So I would first say that it depends on your individual circumstances. Some of those who says, oh, we are working, can we still do that? Yes, if you have been able, you can show your income is low, and then you can not afford to pay the fee for your child. So let's say someone is working and earning 1,800, and he pays rent, bills, other travel, food, cloth, everything includes, and they have family, and they are spending a lot every month, they are in overdraft, no savings every month. Yes, they ask, we are working, is it going to be applicable for us? Yes, if still you are working, you can still give a go, you can still try with the fee waiver. So end of the day, the decision is with the Home Office. Those who are struggling, they can do that, and those who again, I would come to the actual family and private life fee waiver. Most of them, they say, oh, I'm going to apply for indefinite leave to remain. Can I do that? No, there is no fee waiver for indefinite leave to remain. Yes, there is no. And for adult citizenship, there is no fee waiver for that as well. Yes, the fee waiver I've talked about, that is for children. So your 1300 is still there that you have to pay. I will just mention this again. So with the fee waiver of family and private life, yes, you can do that. Anyone on 5 years route, FLRM spouse, yes, they can do that. Anyone on 10 years route, FLRFP, yes, they can do that. Anyone who wants to switch parent route 10 years to 5 years parent route, I would come back to those documents later, maybe in next program.
Yes.
So they can also apply for that. Anyone who has no leave, they want to go for HRO, Human Rights Application, other grounds, Article 8, and their private life, yes, they can also apply, as long as they can show, as long as they have evidence that they cannot afford to do that. Yes, they can do that. They can apply for it. Another thing, important thing, that what they can do is, if they are working, they have family to support, they cannot afford to pay the Home Office, and the fee for that FLRFP, FLRM, HRO is nearly £2,700. It's been increased now. The IHS is now per year is 624. So if you are going for 30 months leave, it's definitely nearly above £1,500 that people, they are worrying that for 30 months, every 30 months, if let's say someone is on 10 years route, every 30 months they have to pay that. But most of them may be not aware of that you can still apply for fee waiver. There is no condition that if you are working, you cannot apply. Even someone is on universal credit, yes, they can apply, as long as they can prove, they can provide us the evidence that it's been becoming hard for them. And the evidence, of course, is their bank statement. Any other account that they have in the UK, they need to provide the bank statement, and then we can discuss that. We can see that from the bank statement that their expenditures and everything, and then we can do the fee waiver applications. That's the main thing that I wanted to make sure for all the audience, that whoever is listening to us. So and another thing, the spouse refusal is left. Yes. So we will discuss later this last point. So the main thing with the HRO people, they ask and they come, can we go for this? Can we? You always have to have a reason. If HRO basically asks you that if you are in this country, what makes you to live here? How you have become a part of British culture, and what family and friends and your private life that you have established in this country, and what are the circumstances that are stopping you to go back to your country, and you can still try for this. And under another thing, under Article 3, medical grounds, of that application is free. So those who say they have Article 3 grounds, they can contact any severe medical condition, they can also contact. So this HRO, Article 8, where you have your family and private life, also you can do that. And the reason that you cannot go back to your country, you have to provide, and the reason that how you have become a part of British culture, that how you have established your life in this country, you have those reasons. You contact us. The number for the studio is there. The number for Mavalox, I can repeat, that is 0780 300 1377. Email, you can also contact fahad@marveloxsolicitors.co.uk, or you can contact info@marveloxsolicitors.co.uk, and we open Monday to Friday 9:30 to 5:30 p.m. Anyone wants to book the appointment, they can call directly, and we will schedule their appointments. They can come and see. Anyone who wants to who is struggling, working, can't spare time to come, I really appreciate that how every individual is working hard in this country. They still have option. They can call on the number which I'm going to repeat again, 0780 300 1377, and first 30 minutes initial consultation is free for them. So what we giving best as a services, which I definitely want to say here, that is, even someone cannot come to the office and they have question, they want to have advice, they just pick up the phone, call and get free advice. And of course, but there has to have a case. Most of them, they if they have someone back home in Pakistan, India, Bangladesh, Ghana, Nigeria, Nepal, any other country that we have clients from, I may have missed the names, I'm sorry if for those who are from different countries, Albania, let me say Albania as well. So Afghanistan is very, very important, that we have so many clients from there, and we have a big community of our Afghani brothers and sisters that currently what's been happening there, and they have been given option from the Home Office. I know this topic wasn't there, but I can also explain, because most of our Afghani brothers and sisters, they come and they call and they ask. They have their family back home, and the Home Office also announced a scheme for the resettlement for those. So what's been happening with that? The Home Office over 4 years, they have announced that they have to, because there are some agencies involved, like through the I would say through the Refugee Convention, through the United Nations that are working there, and the Home Office has mostly given them right to choose those who's been struggling, and those who has already informed to the Home Office over the phone that they have families here in the UK. They can contact those people. They have offices of United Nations offices in Afghanistan. They can contact, and this settlement for those individuals who are struggling with the families, they can do it through them. And then people, they ask when they come, what happens when they come? Then they can contact us all anytime, and we are here to help them. That what's going to happen next. Most of them will be looked after, has been already looked after by the UK government, so they don't have to worry about it. Those who they have their spouses in Afghanistan, and they want to bring them here. So currently the embassy is closed in Afghanistan. There is no the UK United Kingdom consulate is not operating there. So what they can do, they still have option, because two neighbor countries that they can always go to, Muslim countries, Iran and Pakistan, as long as they have valid visa for Pakistan, and even Pakistani government, they also allowed them to issue visas for them. So this is one of the relaxation for them. In Iran, they have also allowed them to apply for visas, especially for these purposes, if they have the appointment there. Like most recently, I had few clients, they had the visas for Pakistan and Iran, and I booked their appointments in Pakistan to go and do their fingerprints. So most of them who are thinking that, that they, if their spouses are there and they cannot do the fingerprints, and what they have to do. So this is the key point. They first have to apply for those visas. Can be either Pakistan or Iran, and then they can do their fingerprints in there. So currently the timeline of every single application, even its appeal for judicial review, judicial reviews may be faster than appeals or application time. Any NT clearance especially, because NT clearance. So most of the people, they come when they did their application, let's say in March or in February. So most of our clients, we have received the emails for them that the process may take longer than the actual time. So let's say if before this war, Ukraine and Russia war,
Yes.
Was started, the normal time was 8 weeks, 10 weeks. That was the actual time that the Home Office was taking for spouse NT clearance, not in the UK, not the FLRM I'm talking about, the NT clearance outside the country. So the time period was 6, 8, 10 weeks that they were normally taking. But now they have sent emails to every individual that whoever has applied, and for this they have to may wait double than the normal actual time. So all of those who have already applied for this, they need to consider this into take this into the knowledge that the time limit has been increased, whether it's outside the country or it's inside the country. So excuse me. And for visit visas application, people, first question they ask, how likely we will be granted. Before I go there, so let me tell them the time scale for that as well, so that they would understand that because we have currently in some application in the process, and most of our clients, they ask the time for the visit has now been, because previously we even had the decision in 7 days. We had the decision in 15 days. But now the time has been increased to 6 to 8 weeks. Normal time that the Home Office is taking, the Home Office is taking even for visit visas. You've been very lucky if you get the decision early. I know in the audience there would maybe someone who's listening and is saying, oh, I had mine in 2 weeks. So let me make that per individual clear that maybe you get that early, but it depends to the caseworker who's going to make your decision, and the backlog that they have, because they're currently facing huge backlog due to the application from Ukraine and Russia. So this is the major thing that has been happening. And before we go for next family, most of them I know must be waiting and want to listen what's happening with Zambrano, because there was a time when the Court of Appeal gave ruling and asked, I would explain in simple language so our audience would understand that, because most of them they don't understand that when the first ruling came for Sanya in 2011, and the first regulation came into force which was regulation 2006, when we became the part of the EU, and then the EU rights, free movement rights were given to EU people in this country. Then it was changed with regulation 2016. The definition of Zambrano carers. Who are the Zambrano carer? Who have their British child in the UK, and they are the primary carer. The primary carer is the carer who has the main responsibility. The secondary is the secondary, but the primary is the main one. So this, even most of the people, even they call and they ask, oh, my lawyer told them to make as a secondary carer, which I would clearly say that this application was, even in the beginning, it was for the primary carer, not for the secondary carer. So those primary carer who were previously granted according to previous regulations, the definition is clear in there. They were granted under regulation 2016 or 2006 Zambrano carer rights, that the person has British child and they have spent 5 years and they have been granted Zambrano rights, 5 years leave in this country, then they are eligible for the indefinite leave to remain. So when this ruling was came out by the Court of Appeal, Ehtesham, this is very important point that I want to say here. Everywhere on YouTube channels and people's status, everywhere it was mentioned, oh, come to us, do this, do that, so come, and they charge crazy money, like whatever money to their clients. And because I'm getting calls and people, they say that they have paid this much, they were made, most of them were made sure that yes, do that, you have a good chance, do that, but they were forgot to tell them. I wouldn't say that anyone did purposely, but I would say most of them forgot to tell, to give them proper legal advice, that even now that the Home Office has updated when the Court of Appeal asked Home Office they need to make changes to Appendix EU, which came into force in 2019. That was the replacement of Regulation 2016. So they were asked to make changes into the category of Zambrano carers, and most recently, a few days back, the Home Office has updated their final version, and they have clearly mentioned that those individuals who already have their 30-month leave, whether 5 years or 10 years, parent route, child route, they cannot switch to Zambrano. Whether they have spent 5 years, they cannot now apply for indefinite leave to remain directly, because they already have leave. They are on the route, and this is understandable that why people were interested to do this, because this first thing, this was free. Second thing, whoever has spent 5 years and has 5 years and has a child in the UK and they have spent 5 years together, so they've already they thought probably they have a chance to get indefinite leave to remain. But there is a very important point that they missed, and even they were advised properly. Even the Home Office has allowed 6 weeks for those, which is very important. Please do not confuse this. Who can apply this Zambrano now? Who have a British child, but the condition is they have no leave in this country, no leave. They have currently no leave under parent route, child route, any partner, any route. They have no leave. And the child was born before 31st December 2020.
Yes.
So any one of you are still confusing yourself, I would repeat that Home Office has allowed, even at that time, most of you who are listening this program, I made this clear to you guys that please do wait, because you will be given 6 weeks when the Home Office will update the final version, especially for the Zambrano rights, the Home Office will give 6 weeks to those individuals who are looking to apply for this. So there was no point for them to do their early application and paying thousand whoever, because there was no fee. Because since the new version has come, most of people, they are crying, oh, we were not being told that the Home Office will give 6 weeks. The 6 weeks time period was very, very important. That, look, the new version has came up, you have 6 weeks, whoever differs for that, and there are hardly there are just few people who can apply under this route. And most of my clients, they are so happy. They are so happy that I have put them on hold. I have told them clearly, you need to wait. The Home Office has asked the Court of Appeal, has asked the Home Office to reconsider and see their proper rules that they had in Regulation 2016 and reconsider. They were not being asked or they were not being forced. That is what I explained. That they were not being forced to do the same thing. So Home Office has now updated the version, which is in very simple and clear language. All of you can type and read it. That what does it says? Any one of you differs under the same category, has a child before 31st December 2020, and they have still not applied for any leave in the UK, they do not have any status, they can apply for Zambrano. And again, please don't confuse yourself. You are not going to get indefinite stay away unless the child was born 5 years ago. You are the primary carer, you have the evidence that you've been looking after the child, you are a registered parent at the GP, you register parent at school. If the child is 5, definitely the child is school going. You are registered with nursery, school, you can provide all the evidence, then you can apply. If you have spent 5 years, then you can apply for ILR. But it's the Home Office discretion whether they allow you first 5 years leave under the Zambrano or they allow you indefinite leave to remain. We cannot say for definite that if you have spent 5 years and you do not have any leave and you will straight away get that. No, if someone is telling you, the person is lying to you. So this was these new changings that has happened, and more coming. I have not explained those because of course we have short time here, and we understand that we cannot run the show for that longer, so we have to stick on the specific topics today that we have already discussed. So I would now say if we can discuss the spousal refusal,
Yes, exactly.
that'd be great. I think that was one of the topic that you mentioned earlier in the beginning. With the spousal refusal, most of them, those individuals who are having this issue that they have got refusal for silly things, mostly they get refusal for the financial requirement, they get refusal. Also, some of them are not being able to establish their relationship. The guidance says that you have met, you have lived, even for the shorter period of time. It's not something that you can marry over the phone, except the Home Office has given discretion to those. There are some of the discretion even during when we were part of the EU, that if two parties are here, and especially most of my clients from Ghana, they could have registered their marriage in Ghana, and that the marriage was valid. Even they were here in this country, that marriage was registered. Even both parties were here, even if one of them was there. So they could have that registration, and that had worked for my clients in the past. So if someone is, of course, outside the country, yes, I would say they're married back home, their marriage certificate is valid, of course, if they both parties are, let's say, in Pakistan, in India, in Ghana, in Nigeria, couple is living there, one of them is British or has settled status of the UK. There are some requirements, financial requirements. Why do I have to mention this? You can rely, if you are working full time in the UK, the threshold to meet the Home Office requirement is 18,600 per annum. I had a question previously. Someone said, I have a question. I've only worked 6 months with one employer, and how is it going to work? And I said to him, like, how is this going to work? It's because you need to provide 6 months salary slips. That's it. You don't need to worry that you don't have P60. As long as you have worked 6 months with the same employer, the Home Office 6 months salary slips times into 2. As long as you meet the threshold, you are good to go. You need a letter from employer. The Appendix FM under the financial rules, it clearly says 6 months salary slips, 6 months bank statement where your salary goes into, and an employer's letter confirming the nature of your contract. When it comes to nature of the contract, people, they ask and say, what does that mean, nature? So nature of the contract means that what type of contract you have, full time, you have hour mention on that, you have even a 0 hour contract, but you are working for 6 months, and they can give you letter, you have salary slips, you have bank statement. Make sure you have to bear in mind the time of the application. I can give an example previously that a person came in and was keep asking me the question that what documents do you think I need. I told him, I said, you can come, we can discuss, and I just explained him, I advised him, and after 4 months he came back and he said, I was going to give you, but then I realized that you've already given me enough information, and I should better do this myself. The person did the application, and that was refused. Then the refusal letter, when I saw, he was struggling to meet, because people, they think that the Home Office may not call them, but in most of the cases, the Home Office also, when you submit the application, the Home Office calls the couple individually, and they may not give time to one to tell another partner, I had a call and this. No, so that can be at the same time. And if you are not matching, then of course, and people, they get confused. Most of them, they get confused. It's not the matter that they are not matching, but of course they are confused. So when we do application, we explain, we do the representation, we explain that how the couple met, where the couple lived, what was the date when the couple first met, when the relationship was started. This relationship was started through the WhatsApp. They met in a party. They met through someone. They were here. That is that's how they met. We explain. Then we explain under the case laws how the family rights they have raised, how they qualify under this rule, how the Appendix FM eligibility, suitability, financial requirement, how they qualify under that. We explain in representation step by step. Then when I showed this to my client, and he understood that how it's a hard work, it's not an easy job, it's not something that you can do yourself. And let's say if you do yourself and then you make a mistake and you get a refusal, and then you come back, then The couple who are in relationship, they are in a hurry to meet up each other, to start their relationship and to live together permanently in the UK. Let's say if someone has a refusal and then they had to wait, even now due to the war they have to wait more. So the best thing is, when you come, take proper advice. If someone is advising you, take list of document and let us do the case, and we will work properly and would get you through this. And then you need to listen, you need to follow that. And the person who came and the refusal was on silly grounds. They made the refusal on the financial requirement, because the person thinks when he submitted the application, he just submitted his salary slips for which was not counting the actual period of time that he should have counted, and then it was straight away refusal. Even the employment letter wasn't there. Which is very, very important, one of the main part. So these are the main things that's been happening. I think we have explained briefly every single part that we've chosen today to explain our audience and our clients who already know us at Mawalok Solicitors, and we have explained them briefly. And we have shortage of time. I think if you have any question, I can wind up quickly if there is anything important that I can explain.
Thank you so much, Mr. Fahad, for brief explaining of new immigration laws.
Yes.
And let's come back on our topic, family law.
Mm-hmm.
After divorce, as you explained before, after divorce, mostly parents have trouble for their children's.
Mm-hmm.
So kindly brief about child arrangement orders.
Okay, thank you so much. The way you have asked the question, I'm so happy. You made it easier for the audience, which is very good. Thank you so much. So it will be easier for them to understand as well that the child arrangement order, when we come to that, this is under the Child Act. This is every individual's right who has a child, have their name on birth certificate. Parental responsibility raised when you have your name on the birth certificate. You are the birth father of the child. But when for most of those who come to me, when the non-molestation is involved, when the domestic violence is involved, and one of the other party wants to apply for child arrangement order, how the process works, you can first, if the domestic violence is involved, you can directly go for child arrangement order application. If it's not involved, then you first have to book the mediator. You have to go for the mediation. You need to get MIAM, mediation exemption form, because that is what the family court will look for. If you are going to submit, you have two ways: paper C100 application for child arrangement orders. Then you have online. Don't forget the fee. Whoever struggles to pay the fee, we can also advise them further in next that how they can waive it. So how the process, people when they come and they ask, can you give us the time frame that how long this takes? This is something that judge has to see in the family court all the facts. Child arrangement order, this is one of the main thing that you come when the parties are not together and the party wants to make arrange to see their children. Let's say the child is with mother. Mother is a primary carer. Mother, due to some reason XYZ, mother has not allowed the father. Then the father, birth father has, who has name on birth certificate, has right to go for child arrangement, that he wants to see his children. If something involved has been done between couple, but you are still father of the child, you can still go for the arraignment, and we cannot promise the time limit on that, because when the first hearing with the family court comes, the court gives you directions. And don't forget, when non-molestation is involved, in most of the cases, the judge in the past I have seen with my personal cases has given the order that you should combine both non-molestation and child arraignment. So the hearing for my one of the recent case, we had about 6 hearings where non-molestation was involved, and the judge ordered to combine child arraignment as well. You don't forget, the social worker is involved. Her report is important. Then you have CAFCAS officer, section 7 under the law, under the rules, section 7 report that the court want to see the findings of the officer, CAFCAS officer, that what findings. He individually interviews mother and father, and if necessary, because social worker is mostly involved, who also writes the report to the court, can also ask in first hearing. You get the directions for that, and for those directions you follow in the future, because in this situation is not only one thing involved. Your child arraignment never ends up in first hearing. Of course, when the court gives directions, you have to follow directions. The bundle has to match the directions that the court has given. Both parties, has served the documents legally and provided legally within the time frame to each party. Then the same copies have been served to the court, and they have to complement. And there is very important point here, Tisham. There may be case management hearing involved in this. The case management hearing is the hearing where the court checks your documents, that are you meeting the requirements of the directions, because they do not. Let's say the court has given the directions, judge has given the directions, and you are now going to attend the hearing, and you have not complied. Then you are wasting your time, court's time. You have to, if there is a case management hearing, then you have to attend, and you have to make sure that the hearing has before the actual hearing you have been able to comply with everything. So this is the process that I've explained. I think I've just given the overall brief intro, because there are so many things to explain to our audience, to our clients, but I think...
Mr. Fahad, I have one question.
Yes.
Please explain us some about special guardianship.
Okay, that's fine. So I think this we will keep. I would say this we will keep our last one, and
yes.
Then you will, I think, conclude this. So with the special guardianship under the Act, you can apply. You have adopted, or you have children living with you. You have a strong bond with the person. You have gone through the counsel process. You need to inform them, because in this process counsel is involved. Then for the special guardianship order, there is an application. Then there are witnesses involved in there. Once you do this, you have to show how the child is involved with you. Maybe the needs of the child involved. Article 8 gets involved in there. You have to show that how the child has lived minimum 1 year. It has to be that you have to show how you are involved in the child's life. If the child do not have actual parents with him, what is the reason that the child you are going to apply for special guardianship? I had a very special case that run for over a year. If currently I've just given the overall brief, but in next show I would explain them. The client was from Ghana, how the parents, mother was Ghanaian but became British later, and father, the partner was British. They adopted children from Ghana. They were granted leave to enter in the country, and then the issue came up with a special guardianship order that they had to go through the council and through the social services, that they want to apply for special guardianship order, and then the order had to be submitted, the final applications to be submitted to the Home Office, because the social services are involved and they are concerned. They also want to see your history, that if you have any record on you, any conviction on you, that how you are going to look after the child. So this is a very interesting and important case that I would like to give the facts and the judgment and findings in the next interview then when we are going to have. Yeah. So yes, please, over to you, Mr. Tasham.
Thank you so much, Mr. Fahad. You are explaining to new immigration law and family law. Thank you so much for coming. So let's come back with next week with new topics. Thank you watching us.
Yes.
And giving your thoughts. Please follow and like our Omega Lives TV. And if anybody have any questions, contact with Mr. Fahad. Please. We are already given the number and contact email address. Thank you so much.
And last thing I would like to add, don't forget us, Marvellock Solicitors. Our address 2A Median Road, ground floor office, just 3 minutes walk, literally 3 minutes walk from Hackney Central. Our postcode is E50PL. The contact number you can call 0780 300 1377. Okay. Once again, maybe you may miss this, but I don't want you to miss this. We Marvellock Solicitors are here. We be running regular shows here from Omega TV platforms. Will become a regular family to you guys. Our address for Marvellock Solicitors is 2A Median Road, ground floor office. We literally 3 minutes away from Hackney Central Station. We are on the ground floor. You cannot miss us. And we are popular in the area due to our services. And the contact number that you can contact me directly, 0780 300 1377. Emails, you can email to my direct email, fahad@marvellocksolicitors.co.uk, or you can email on info@marvellocksolicitors.co.uk. Thank you so much for watching us. I hope that I've tried my best to explain your queries, and next Tuesday we will be coming with new answering questions. Thank you so much. Thank you.
Thank you.